Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes.
We're excited about today's episode because we will be talking about some questions that we have seen on different social media platforms in different groups as it relates to family law issues, specifically child custody. With us today, we have one of our fellow attorneys here at Modern Legal, Sabrina Frenette.
Thanks for having me on. I'm excited to go through these.
Tell us a little bit more about how long you've been with the team and what you do.
Yes, so I joined the team back in last September, so September of 2023. I'm mixing up the years already, but so it's been almost a year. It'll be a year in just a couple more weeks here. So and I joined the team right after I took the bar and have been with them, and just every day is a new exciting adventure here.
Yes, a new adventure. And even before you became a licensed attorney, you were actually a law clerk for us for about a semester. Right.
Yes. Yeah. So in the fall of my third year law school, I came here and was interning with the team. And that's what got me excited to move back to Charlotte. Because originally I was in law school up in Boston. Couldn't handle that cold all the winters.
Yes.
Yeah, it was brutal for me. So moved back down and got to come back to my hometown. So I'm so excited.
Well, we're excited to have you not only on the team, which we're always thankful of, but also here in the Legal Lounge, because we see a lot of these questions posted in various places, whether it be on a LinkedIn page or a Facebook group. And I think for me personally, I've had those moments. I'm sitting on the couch with my husband watching a Netflix documentary, which we love to do. And I just happen to swipe across, scrolling through Facebook, a question that's posed. And the question is a good question. And my bigger concern, though, is all the responses. And some of the responses I have seen, they are frustrating. And I want to be like, no, incorrect. No, try again. Like, oh my goodness. And there's so many more factors that we should be discussing aside from the details that are posted in the question.
Yeah.
So without further ado, I'm going to go ahead and just read some of these questions and we'll brainstorm a response. So one of the questions I saw pretty often, it was definitely a question asked more than once, is whether or not I can move with my child out of the state. So I will kick it off to you, some considerations that we want to think about if we're trying to move out of state with a child.
Relocation, especially out of the state, can be really tricky. If you already have a custody arrangement in place, a formal custody order in place, that moving out of the state can make following that custody order practically unfeasible or impossible. So if you're thinking about moving out of the state with your child, you kind of have two options. One is to talk with the other parent, let them know, of course, what you're thinking about doing, seeing if they'll be in agreement with modifying that custody order and creating a new schedule between the two of you. Or your second option is to go to court and have the judge review and ultimately modify that order. But the judge has several considerations, and relocation, it's always a little hard, especially if your child has been living in the state for a long time and has a lot of connections here, has been developing really well in North Carolina. Judges are typically hesitant to uproot a child from their life and from that security. So that's something that we always talk through with our clients before they ultimately make that decision.
And it's interesting because when that question is posed, especially with us being here in Charlotte, where the border between North Carolina, South Carolina is, 20-minute drive, that's very different when a parent is just moving to South Carolina, if they started in Charlotte, versus if they're moving to California. Um,
Mm-hmm.
so to your point, let's say there's a parenting agreement or a custody order that awards mother and father week on, week off. You could probably still do the week on, week off, especially with a Sunday exchange if both parents are relatively close to the school, even if technically, physically, one parent is across the border. But the child very much cannot go to school physically if they're with mom here in North Carolina for 1 week and then father has moved to California, and they're trying to have that parenting arrangement continue. I'll go one step further. Another note here is the child even of age to be in school yet? So I have seen courts take under consideration, in the one case I'm thinking of, father was here in North Carolina, both children were born here in North Carolina, and mother moved to I think it was Ohio. And the son was 2 years old, the daughter was a newborn, and at least for the first 2 to 3 years of the custody arrangement, the judge went ahead and did an equal split, but it was like 1 month with father here in North Carolina, 1 month with mom up in Ohio. However, that was going to change, and did in fact change, because I was with my client for a number of years, to where one parent had the children primarily once school started for both of them. And to your other point, yeah, judges, they're biased, and they, as they should be, because if a child has been in North Carolina, say for 10 years of their lives, we're not just talking about maintaining a relationship with both parents. We're also talking about, okay, where's the child's pediatrician? Where's the child's teachers? Where's the child's network of friends and support? If there's any other factors, is the child, we're recording this in the midst of the Olympics, so is the child's Olympic coaches, here in the area, or are you moving simply because you get a better job, or just because out of spite? Out of spite is probably the worst reason to move. And these are factors regardless of the relationship between the parents. The relationship between the parents, if it's amicable, great. But we also have a number of domestic violence situations. And so if there is child abuse or domestic violence allegations involved, we highly recommend to consult with an attorney before you move, at least across state borders. That doesn't necessarily mean you can't move out of the house to another area of town or even another county, but it is be careful moving out of state. I've had the case where I have told my client, do not move to South Carolina, even though we're here in North Carolina in a DV situation, but definitely move out.
Mm-hmm.
That means moving to an Airbnb for a couple weeks. At least let's start there. And then hopefully we can get you an emergency custody order to get you primary custody of the child so that you can move to South Carolina or another state.
Yeah, safety comes first in those situations, but it can be a lot. It can open up a whole can of worms if you move out of the state.
Exactly. And especially if there hasn't been a lawsuit filed or some type of parenting agreement or custody order in place.
Mm-hmm.
If the courts do deem you trying to evade the jurisdiction of the North Carolina courts, regardless of what happened between you and the other parent, then the judge can issue an emergency order for the return of the child to the state and to the parent who's still in the state. And that has less to do with any claims of abuse, and everything to do with the fact that someone just up and moved without involving the courts and involving the other parent. Great response. I'm going to add to that. What about access to information like school records, education records, healthcare records?
I've never seen an instance in which a judge or a court is
Mhm.
ever going to block one parent's access to their child's records.
Mm.
Just because obviously it's important for both parents to be aware of what's going on in their child's life, if they have any health issues, things that they have to be able to properly care for their kid. And so, in that instance, trying to prevent the other parent from accessing information that's essential to caring for their child, a judge is never going to like that. And it
Mhm.
also is a huge disadvantage to your child. They deserve to have both parents be able to fully be parents. Um,
Yes.
yeah.
And be informed. To your point, I've even seen in high conflict custody matters and even child abuse situations where there's been orders where a judge will give sole custody to one parent, but still allow access to records to both parents, just because, yes, parents have a constitutional right. It's what we call the Peterson presumption, but a constitutional right to be involved in the parenting of their child even if they don't have custody. So I have never seen it, to your point. Do I think it's possible? Maybe. But yeah, judges will want both parents to at least be informed, if they still have their parental rights of the situation, both education, medical, and the list goes on, the status of their children.
Building relationships is a natural part of life. But how does the law affect those relationships? Do you want to marry your significant other, but have cold feet from the many divorce horror stories out there? Are you preparing for a custody battle against your ex? That is where Modern Legal comes in. We offer education and knowledge about the law when it affects the relationships near and dear to your heart. To learn more about how family law affects your family, book a consultation with an attorney of our Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal Services at modernlegalnc.com.
Another question I see often, and I always find this interesting, is when does a child get a say in their custody arrangement between the parents? And I think it stumps me, honestly, Sabrina, because I'm like, we do know that children can't enter into a contract until they're 18, right?
Right.
And children are required for a good part to be in school. There's so many requirements on children and limitations to their rights. And I have had the question, like, is it 11 years old? Is it 12 years old? And I'm like, seeing that a child can't even drive at that age, why
Yeah.
would we think that a child has the ability to say what they want? Well, first off, let's allude to what the law is and the legal education piece, but tell me your thoughts too.
Yeah, no, exactly. I will say we get that question a lot. And I think there's maybe like a misconception that children's preference gets a much stronger or has a much stronger pull than it actually does. But I will say so in North Carolina, there is no specific age where a judge is suddenly going to consider the kid's preference. So it's a factor that the judge can use when determining what's in the child's best interest. So if the child expresses, I love to live with mom or I love to live with dad, the judge can consider that in their ruling. And as the child gets older and more mature, the judge may give more weight to that expression of preference. But the judge, obviously, I mean, like you said, with kids who they're kids, so a lot of times we see kids that have one parent that they consider to be the fun parent,
Mhm.
and obviously they want to spend their time with the fun parent, and judges get that, and so at the end of the day the judge is going to look at which parent is making sure that the child or both parents making sure that the child is going to school, living a healthy life, all those things. So at the end of the day, it can be a consideration that the judge has, but the weight of that it varies just depending
Yeah.
on a lot of the other factors involved.
Yeah, on the situation. And And simply put, if my clients or prospective clients ask for like a direct answer, I always say 18. And it's less about that's in the statute, and it's more about the courts lose jurisdiction over the
Mhm.
child once the child turns 18. Because at that point, the child is no longer considered a minor child, and therefore the courts can't dictate where the child lives, with which parent or wherever, really. A
Mhm.
child can move out of both parents' homes at that age without much interference by their parents. Side note here, this is not common, but I have seen it happen where if a child does express a preference for one parent over the other and is pretty strong about that preference, sometimes it backfires because a judge could view that display of a very passionate expression or preference as evidence of parental alienation about that child preferring that one parent. And in our courts, again, regardless of the situation, unless there is harm happening to the child in one parent's custody, the courts very much want both parents to encourage the children to spend time with the other parent, just because if we're able to have even in split household situations, if we're able to have a child that has the support of both parents, that has been proven time and time again to be what's best for the child. And the courts follow that belief. And if one parent has influenced the child so much so that they now hate the other parent without justified cause or a true understandable reason, then a judge may say, okay, this may indicate that actually the child should not be primarily with the parent that the child prefers. And so we would highly caution anyone who is trying to get the child's testimony in as if that would influence the judge in their favor.
I feel like it really looks suspicious, especially if the kid is using language that a kid wouldn't normally use to talk
Hmm.
about the other parent. It just seems obvious to me even that, there's some coaching going on behind the scenes.
Exactly. So I'm going to switch a little bit to a very, very specific question. So the question that was posed is, quote, if my child gets 10 tickets for graduation, which parent gets to decide who gets the tickets? Parentheses, no joke, this is happening with mom allowing only dad to come, not his wife or their child, who is a sibling of the graduate. All tickets being used for more distant family, and child wants no one to fight. Um, that's a hard situation, right?
Yeah, it really is. And my response to that person would be, fortunately, judges don't care about decisions as minor as that one, as
Mhm.
who's going to get the graduation tickets. And I say fortunately, just because at the end of the day, I think it would be so annoying to have a judge telling you how to make every small decision in your life. From a legal perspective, going to court over that issue would pretty much be pointless because a judge is
Mhm.
not going to want to make a decision like that. And to be honest, by the time you even got in front of the judge, I'm sure the graduation would be over.
Yeah.
Um, but from a practical standpoint, and this, doesn't have anything to do with the law, but in thinking about it, I would always talk to parents about the fact that graduation, especially, that's a huge deal for your child. That's a really big day. It's a huge accomplishment. And so when you're thinking about who is going to attend the graduation, consider your asking your child who they want there to support them. And really using their opinion and deciding who's
Mhm.
going to get those tickets, because ultimately I think your child is going to want the people there that are going to celebrate them and who have been supporting them throughout their journey to get that degree or make that next step. So that's what I would say, and that's not related to the law, of course, but just
Yeah.
something that
Yeah.
that I would tell people.
Yeah. And to your point, judges are more concerned about where is the child physically from time to time, if the child is in need of any significant medical assistance. And although I get it, especially to the child and to parents, a graduation is a big deal. And there'll be, I mean, I still have a picture up of me with my brother and my mom at my law school graduation. I get it. But I will say this, it's the most important person is the person you're celebrating. And if that is the child, like you point out, then maybe the child's preference should be given more weight by both parents in determining where those 10 tickets go. And I get it. That 10 number was probably instituted by the school because they only have a certain number of seats. And if a court were to get involved, trust me, they're not about to start assigning, ticket one mom, ticket two dad. Like the judge does not want to, definitely, but definitely does not have the time or resources to get into that specific of a decision between parents. And when you are taking the child's consideration in the child's choice into consideration, I mean, like the post even references, the child doesn't want anyone to fight. So maybe it's, hey, no one's going. Here are the 10 tickets. You tell us how you'd like them to be assigned. And maybe the child only wants 8 people to attend. Who knows, right?
Mhm.
And if that's a little too much responsibility for the child, because maybe, and I'm thinking, high school graduation,
Yeah.
but is this middle school graduation? Is this kindergarten graduation? Right? Okay. At
Right.
that point, it's like, well, then maybe if there is contention and the parents are separated, then maybe to do what's right, maybe just to do what's equal. So mom gets 5 tickets to decide how she disseminates as she sees fit, and then dad gets 5 tickets. And my hope would be that if dad only needs 3 tickets, that the other two he gives back to mom for choice. But it really is working through these almost like negotiation type tactics, fairness type tactics to get through a decision such as this, because this is not an appropriate question to bring to a courtroom.
Yeah, and you're gonna have so many other, I mean, especially like we were talking about, if this is a kindergarten graduation, you have
Yeah.
several more graduations to go. So
Yeah.
it's gonna be good to figure that out and just set a fair precedent in the beginning.
Exactly. All right. Shifting to another uh, question. Parents have the constitutional parental right to decide where children are physically, where they are in terms of, where they go to school, what type of religion, beliefs, or practices that the child will be exposed to, even down to extracurricular activities. And the reason courts get involved is to help separate that and to assign, you get this week with the child and you get this week with the child, is to assign some of those rights out. However, this is a good question because it comes up often is, does that extend to deciding what happens when the child is with the other parents? So a big question that comes up is, quote, can I keep my ex in-laws from seeing my children?
Yes. Yeah, we see that one come up, especially, yeah, if one parent does not have a great relationship with the ex-in-laws.
Yes.
Um, I will say, so in responding to that question, obviously, when the child is with you, you have the right to make those day-to-day decisions of who the child is going to be around, what you're going to do with your child, all of that. But when the child is with the other parent, again, they have that same right. So if they want to have, their child spend time with their grandparents, then that's their right to have them do that. And I will say too, obviously, you might not have a great relationship with your ex-in-laws, but it's important to recognize that your child may still have a great relationship with their grandparents and may still want to spend time with them. So in terms of that, and again, this isn't necessarily a legal comment, but I always think if you're going to do what's best for your kid in the long run, it's always great to encourage those relationships between the family if they're healthy, of course. But yeah,
Mhm.
again, if they're with you, you're not obligated to invite grandma and grandpa over to spend time with the child. But if they are with the other parent, then they do have that right.
And it's not just the grandparents, right? It does extend to, depending on any specific provision in a parenting agreement or custody order stating otherwise, that could be, father's new girlfriend or mother's new boyfriend. That could be bringing the child to, say, a concert of music that the other parent doesn't like, or one parent bringing the child to a religious institution that doesn't align with the other parent's religion. And so it really is, now that there's two households, then the child gets exposed to two households worth of different experiences. And you can't really prevent that. Now, side note here, there's always it depends factor. Now, of course, if there is a third party, and what I mean by third party is someone other than the biological and or adoptive parents. But if there is a third party that poses a significant threat to the child, and we have had those cases where we've had convicted drug dealers, individuals that have been shown to physically abuse the child, or otherwise expose the child to illegal behavior, then that very specific situation can be a factor. So I have seen judges state in orders that this child shall not be exposed to or left alone with this third party individual because of the threat of harm. Even that, though, it's very hard to enforce, right? It's one thing if everyone is at a soccer game and you're in the public and everyone has their, cameras, smartphones out taking video, and you see, evidence of that violation. But it's very different if, say, that a third party was banned from seeing the child, but the third party comes through the back door of the other parent's house, and they're there, for an hour, right?
Mhm.
And you don't know what happened. Your hope is that the child wasn't left alone with that third party, but then it becomes an issue of enforcement, whether or not we can prove that that third party was around the child when they shouldn't have been.
Yeah, no, enforcement's definitely a big one because, yeah, we do have people that, and it's not even for a safety reason, but they just don't want their child around mom or dad's new partner or
Yeah.
significant other. And it's like, especially when there's no safety issue, there's really not a lot we can do. But yeah, and in terms of proving that, that's even more difficult. Like, we're not going to be setting up cameras outside someone's house to.
I mean, we have in that case too, but yes,
Yeah.
generally we do not advise that either.
Yeah.
It's a good question, though.
Mhm.
Another question, what do I do if my child refuses to go see the other parent? And we already have a custody arrangement, we already have a parenting agreement, but the child just doesn't want to go. What do we do?
If your child is refusing to go to see the other parent, as a custodial parent, you have that obligation to essentially, you have that responsibility to essentially have your child cooperate, and go with the other parent. So you need to make those efforts to encourage your child to go see mom or dad. I think it's also important, though, to understand why the child isn't wanting to see the other parent. If there is a genuine safety concern, obviously that's a completely different issue. But if there's a somewhat minor reason why your
Yeah.
child isn't wanting to go with the other parent, then you need to be the one to basically force them to go.
Yeah, I actually I have a few examples that came to mind as you were pondering
Yeah.
about those scenarios. Is I've had the case more than once, where one parent gets a new pet,
Oh,
whether
yeah.
it's a cat or a dog. I think your memory is probably
Yeah.
remembering some of these. But like, let's say parent A gets a new dog and parent B doesn't have any pets because they're allergic. I have seen the child not want to go to parent B's house because they're like, but I want to play with the doggy. And who doesn't want to
Right.
play with a doggy, especially a puppy? I get it. I get it. Yeah, that parent with who just got the new dog still has to encourage that child to go to the other parent's house. And if the child starts, crying and gets really upset because they just want to spend the afternoon with the dog. It's similar to getting the child to their first day of school. First day of school, especially, in kindergarten, when they're younger, it's very hard. But for the most part, especially because it's legally mandated, for the most part, I would say parents have gotten over that hurdle to get their children to do what's best for them, even when they are revolting or crying or having a temper tantrum. And it's important to compare the two, right? So if your 5-year-old doesn't want to go to the other parent's house because of the new puppy, or they have a video game that they just started, or whatever the reason may be, or their best friend is home for the afternoon, you still got to encourage them to go see their parent. And my hope, though, more importantly, and this is not legal advice by any sense of the word, but definitely a practical hope, because of the goal of doing what's best for the child, is that both parents will work together in that situation where, okay, maybe we all play outside in the front yard with the dog as we transition the child to the other parent's care. Or if, your daughter's best friend is home for the afternoon and just got in out of town and definitely wants to spend time with the child, maybe the other parent can then invite that child over. But that does require some communication between the parents, right? Because the parent A needs to tell parent B, hey, our child's best friend just came home and child has expressed that they want to spend time with them, and not use that as a tool to keep the child from staying with the first parent A in this situation, which would then lead to the parents not following the custody arrangement or parenting order.
No, exactly.
That turns into a tricky situation, because you think what's best for the child is to acquiesce to what the child wants. But simply put, if I wanted ice cream every day when I was a kid, I would have a lot more health problems than I have today. And trust you me, my mom would say no. Or,
Yeah.
and it's one of those, let's balance it, and to equate, going on your first day of school to going to see the other parent. That
Mhm.
level of responsibility, even if, and I get it, there's a reason why the parents are not together in a marriage or in a romantic relationship anymore, but that doesn't stop what's best for the child.
No, I think that's such a good point and such a good comparison to draw between maybe a child being upset about leaving one parent's house to a child being upset about going to school. Because, yeah, at the end of the day, parents are always having to sort of force or strongly encourage children to do things that they may not want to do. And yeah, whether that be like getting a vaccine or something, and no child likes going to the doctor usually. So I know I definitely didn't. And, my parents still brought me kicking and screaming and made
Yeah.
sure I was healthy. So at the end of the day, that's really what it's all about. And yeah, of course, like you were saying, just because that relationship didn't work out between the two parents as a romantic relationship doesn't mean that the other parent isn't a good mom or good dad. And your child deserves to have that relationship with them too. So,
Agreed. Talk about the birth certificate, because the birth certificate, it's interesting. I feel a lot of people put so much weight into the birth certificate. It's been more than once where I'm like, incorrect. That's not how a birth certificate works. By its very existence, it's exactly what it means to be. It's a certificate to document the child's birth. It does not necessarily impart custody rights. It does not necessarily determine custody rights. But yeah, let's talk about the concept of the birth certificate and some legal implications. Let's start first with if the parties are married. So if the parties are married, what's put on the birth certificate?
so if the parties are married, then the husband is presumed to be the dad of the child. So the husband's name is going to be put on the child's birth certificate as the father. And generally, that father's last name, or the husband's last name, I should say, is going to be the child's last name. I guess there are some situations, I rarely see it, but there are some situations where parents agree to a different last name. And generally, if they're both in agreement, then that's fine. But typically, it's going to be the husband's last name that's going to be your child's last name.
Let's back up here. Hopefully, you're only having sex with your husband if you're a wife. And I'll get to the same sex relationship factor in a moment. But if you're not and you're having sexual relations with someone outside of your husband, then that person, that male in this situation, may be the biological parent, but isn't necessarily added to the birth certificate right away. And that's when a legitimation and paternity action would need to be taken on to essentially remove the presumptive father being the husband and replace it with the biological father. I'll say it this way. All of those individuals would need to know what's going on.
Yes.
So I'll put that information out there. And so when individuals come to me and they're like, well, especially possible fathers, and they say, well, I'm not on the birth certificate, I don't have custody rights. That's incorrect. If you are the biological father, the biological parent, you have custody rights. It's a little longer of a process. So we'd have to file a complaint for child custody. We'd have to ask for a DNA test. The courts can order the DNA test. And if the DNA test comes back that individual is in fact the biological parent, women, they kind of know that they're about the biological parent, right? For the most part, unless they use a surrogate. But fathers, not so much. And so if a father is found to be the biological parent, then that we can get the order that changes the birth certificate. And that's what I mean when I say the birth certificate is not binding on custody rights.
Yeah, no, that's such a great point. And yeah, I think a lot of people give a much stronger weight to a birth certificate than they need to. Because they can be wrong. They can be wrong all the time.
Yeah, biology is the one that determines who the biological parents are, not a birth certificate, not a document signed at the hospital, right? And filed with the birth records office.
Right.
Now, switching gears a little bit, just to show the flip side of that scenario, what if the mother at the time of pregnancy, and I point that out because obviously pregnancy needs to occur prior to birth. What if the mother's not married at time of pregnancy?
So if mom isn't married, then there isn't that presumption, of course, of who the father is. So at least on the birth certificate, usually it's just going to be mom listed unless biological dad comes up and, starts to ask for paternity testing eventually. So at that point, mom gets to decide what last name the child is going to have. So a lot of times, she's going to use her own last name.
And that's important as well. So we have the cases where there is no father listed, or maybe there is a father listed because someone said, no, I am the father, at least at the hospital, and was there at the birth. But again, that does not mean that that's set in stone and that someone down the line gets DNA test and proves that, in fact, it's a different person that's the father. And so that's really important to note because we do, as a society, want to make sure children are connected with their biological parents, if possible. Now, that does not mean that, say someone can adopt the child, right? That's a different legal proceeding. And even if, say, this person that wants to be the father because there isn't a father figure in the child's life, that person can pursue an adoption, especially if they have the consent and support of the mother, the biological mother. And so that's when, when we say it depends, there's just so many factors and different holes we can go down, if you will, when it comes to birth certificates, custody rights. And I'm going to touch on the same-sex marriage thing real quick. It definitely does work a little bit differently, just because biologically two women cannot birth a child two men cannot birth a child from a biological standpoint. But that does not mean that you cannot have a same-sex couple as the legal parents of a child. So in those types of situations, I basically take the birth certificate and throw it out the window, because in that situation, we're dealing with a much different situation. And go one step further with same-sex couples, they more so than maybe other couples will be able to adopt. And once you're the adopted parents, from a procedural standpoint, your names go on that birth certificate as if you are the biological parents, whether that is with same-sex couple or otherwise. And that's to provide just some consistency for the child, so they can go out into the world and say, these are my parents, here's my birth certificate to demonstrate that.
Yeah.
We can talk all day about birth certificates and all those documents. And actually, before I forget, the presumptive stance that the law holds about the husband being the father, it is at the date of the start of the pregnancy.
Mm-hmm.
So what does that mean? Well, we've had couples here in North Carolina, they'll separate. And we do require a year of separation before either party can divorce. And yes, a person who is separated under North Carolina law can start dating again. They can start having sexual relations with other individuals. And let's say 6 months after the date of separation, the soon-to-be ex-wife gets pregnant by another person. Other than the husband, because they were like, I'm done as of the date of separation with the husband. Well, guess what? They're still married. So the husband, even though he literally is not in the picture, not in the household, not in any romantic relations with his wife, because they have separated and they've started that 1 year, that husband still will need to be basically drawn in to any paternity and legitimation issues from a legal standpoint, because they're still married. So to all my ladies who are separated or about to be separated, be careful who you sleep with, because then you could be in possibly getting pregnant by someone else, while your person that you're trying to end a relationship with is going to be presumed the father.
Yeah, it just becomes a little more complicated than I'm sure anyone wants to deal with. So.
Yes. Anyone. Yeah. Because you're like, oh, well, I'm done with that person. I'm separated. I'm just going to wait out the year. It's a little bit more tricky than that.
Yeah.
So I guess this all comes back to, the premise of why I get frustrated. At least this is probably a personal issue, but I get so frustrated with a lot of these questions being posted on social media, just because it's never that simple. Mm-hmm. And I highly encourage individuals who have such questions to either check out our resources or the resources of another family law firm, or if possible, sit down with a family law attorney, do that consultation. I know pretty much no one allows for free consultations, but it's worth every penny if you're able to get legal guidance on your specific custody and child situation.
Yeah, I always think about, if you're Googling your medical symptoms, you're going to get some crazy answers. And if you're Googling your legal situation, you're going to get the same. So it's worth it to go and talk to someone, because everyone's situation and everyone's life is so unique, and their needs are so unique, that getting one general answer is probably not going to be the one that best fits your situation. So go and talk to someone, please.
Agreed. Well, Sabrina, thank you so much for joining us today on the Legal Lounge. I hope that our listeners got some valuable information, and we hope to see you back soon.
Thanks, Teresa.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.